Alexis Rachel Leanne Seiler, 267840618A and R. Somebody wrote down on here being discharged today. Are you Ms. Seiler?
Yes, I can.
Your name?
Alexis Virtual Being.
Did you talk to Mr. Crawford yet?
Yes.
Oh, Simon.
He was supposed to.
He's coming in.
All right, let's take these. All right, so I had Alexis Rachel Leanne Seiler, 267840618A and R. Okay, your name again?
Alexis Virtual Being silent.
Like their property in the silent.
She pled the public nuisance on April 29 and 26, which was a civil infraction plea, reduced from the resist and obstruct, and then the operating with the impaired due to the consumption of drugs. She pled to that day. I ordered the screening and assessment. We adjourned it a week. So she was an inpatient.
Correct. Sacred Heart and Clarity.
Oh, and Beth, see if she's got proof of that, will you, please?
Yes.
Is that the
Just wait one.
probation officer lady?
Yes.
Yes, I talked to her.
She's.
Oh, boy. Let's go here.
And Judge, I'm pretty sure that Miss Wilds does have the proof because she did communicate with me about Miss Seiler also.
Do you know where Ms. Wilds is right now?
That I do not. Let me peek over and see if by chance she might be in Judge Hesson's, but no, I do not see her in there either.
Did you have a chance to review this report with her?
I had the opportunity to report, Your Honor.
Are there any material? Good.
There are no request for material revisions or deletions, Your Honor. My client believes that she can comply with these recommendations, Your Honor. Her only issue might have to do with those that require money, Your Honor, because she's away getting this treatment.
You don't look that good. Is something wrong?
Huh?
Is something wrong?
I can't sit still. I relapsed off of Suboxone and I just got back on it. I went through really bad withdrawals about it and I can't sit still yet.
So again, her finances are a little messed up. You know, she has a job, but they have it on hold for her now. So if the court would try to take these on finance and cost you to appreciate it, she's gonna need a payment arrangement. But she's prepared to comply with everything else, Your Honor. She realized she needs some help. She's working on doing some stuff. She wants to improve it.
Are you going to anybody now? Any treatment?
As soon as I have an appointment to get back on my health insurance. Me and my doctor were talking about taking me back off the Suboxone and giving me the Vivitrol shot. I
Okay.
don't know if you know what that is.
I know what Vivitrol is.
He's gonna give me that.
This is like I'm not trying to make you feel bad, but this is bad stuff. I'm reading this report and while I appreciate your honesty, you got a problem here.
I do.
You live in Taylor.
I do. I actually just talked to my kid's father the other day.
Ms. Wild's your name?
Elizabeth Prosecution.
I know we're along the process here. She went to Sacred Heart.
Yes, yes.
What
I
did
got the
they,
verification of her admittance. I spoke with Miss Seiler on the phone. My understanding she was actually gonna be on Zoom today because she was getting discharged later today.
getting discharged? You mean, okay, I
But
got
I
it.
got her home yesterday.
What about her in sobriety, Corey?
I think she would be a great candidate for sobriety court, but she has expressed on many occasions she has zero interest in.
Why don't you want to go into sobriety court?
If it is to do with payments, I don't mind doing it. I really make it by as it is with my child support getting taken away. I barely make it by. I have to pay my dad. Like, I don't make it with a little bit of money I am making. I was doing 3 jobs and it was killing me. I can't do 3 jobs anymore. That's why I relapsed in the first place.
She participated in 23rd District Court sobriety court program prior. I don't know if she was successful or not. I think that's what plays a role in her decision. And it wasn't just sobriety court. She had expressed no interest in even probation. And again, this would be prior to her going inpatient.
There's not financial driven, it's not.
Yeah, I know, but you can't have it both ways. I mean,
I completely,
ma'am, just please listen to me a second. You can't just say, I can't do that and I don't want probation and go light on the fines. And you dug a deep hole, man.
I know I did.
I mean, you got all kinds of drugs on here. I was almost blushing when I was reading these. So how are we going to wean you off it if you can't afford the test and you don't want probation and you don't want sobriety court? How in the world are
Sobriety court.
it's the same thing as what you did in Taylor, it sounds like.
Your report offended his tender sensibilities.
Like it's a
I
joke.
completed with flying colors there. I had not one bad drop there. I gave excellent hearing.
Well, good, then do ours.
I will, but I can't afford to pay 25 for a blow and 25 for a drop. I don't mind dropping. I don't mind blowing. I just can't pay
25 for blow isn't bad.
that high. I owe so much money on the car
Oh, wait. That's not what she's talking about.
payment. I pay child support. I have to pay $250 to live with my dad.
Okay, so you give me an option then that you can live with. Because we can help you. I can give you time to pay on this, but we're going to put you through a bond phase. We're going to put you through a bond phase. And in that time period, you're on your own. Once you get through the bond phase, if you get through the bond phase, we have grants that can help with testing, that can help with deductibles on treatment, that can help with sober link devices. We can use grant money to help you.
Okay.
The problem is we can't help you until you're in the program, and we're not taking into the program until we see how you're going to do and if you're taking it seriously. So I can do this. I can adjourn this for a month and I can put you on the bond phase right now, but do know, what are they paying the bond phase again?
It is different than Taylor. Taylor, they pay for testing. Our testing is 15.
Right.
Drug of choice, I would probably recommend for Miss Seiler that she actually tests 3 times a week as opposed to 2 with a sober.
It's going to cost you $45 a week to test. I get that that's a lot of money. But we can't have you in a sobriety court or drug court if you're not testing and we can't verify that you're remaining clean. Now, I would have to tell you, based on what I've read here, I'm not trying to make you feel bad. This doesn't make you a bad person. But your life depends on this.
To be honest with you, going to rehab, I'm scared of being home because I have to help with that talk off.
All right. We can help you. You can't use that language in here, but we can help you. Let's get her on a bond phase. Let's try to move this one through quickly. We're gonna get you on a bond phase. We're gonna set you up. You're gonna listen to Ms. Wild. You're gonna do what she tells you to do. I'm gonna adopt all the bond conditions that probation's recommending. And we won't make it a long one. We'll just set this out for a month. I might have to go to whatever the second Wednesday is of the month or something, Heather. So give me that as a sentencing date in July. And we can help you. You got to want to have help, but we can help you. We had a great session this morning. I wish you could have been here and seen that. I really do. We're going to set a sentencing date in a month. Give me a date if you would, Heather, please.
You are off on that second Wednesday, the 8th, so we could do the 15th.
Yeah,
Or
let's do the 15th at 8:30. Listen. Are you going to try to work at Staybridge?
I go back Friday.
Okay. You're staying with your dad and brother, right?
Yes.
You can.
I don't get it. What's the game here? Does she just not want to test so she can keep using? Is that the whole idea? Because it would seem to me that any alternative to drug court would be worse, but I don't know.
turn your life around here. You got to stay away from this stuff. That's what we're doing, July 15th at 8:30, okay? All right, you're gonna go down the hall, get your notice, and you're meeting with Ms. Wilds. Give it a chance. Give it a chance, please. Hang on, is that side? Yeah, that goes with that one. And this one goes in Matisse. I don't know what I'm doing. I got no fighters. Musso. Daniel Christopher Musso, 26W8422220. I'd like the victim up here, Desiree Musso, please.
Morning, Your Honor, Mike Clark, is representing Mr. Musso, so station in the record.
Daniel Christopher Musso.
All right, your name, please. Your name, please.
Desiree Musso.
All right, so defendant pled here to telephone harassment under section 771.1, and he was referred for a pre-sentence. Actually, he pled, I believe the plea was no contest. So I did say I would take it under 771.1. It says ongoing family court in the bottom of the stipulation, defendant in therapy, therapist present today. Is the therapist, your therapist present today?
Not today.
Not today, it's Friday.
All right, so let's figure out what everybody's going to say here and do here. What do you have to say, Mr. Crawford? Did you review this report with your client? And are there any material additions, corrections, or deletions?
We have a review with my client, Your Honor. We had no material additions or deletions, Your Honor. He believes he can comply. Moving forward, Your Honor, we would ask that the court adopt this recommendation as presented.
Sir, is there anything you would like to say?
Just that I'm very sorry for harassing.
Okay. All right. Ms. Musso, I want you to take your time. I can tell you're a little upset. Just I want you to take a deep breath, and I want to listen to anything that you want to say to me, okay?
The mental, physical, emotional, psychological abuse that me and my children have experienced at the hands of this man is nothing short of heinous. My kids are scared to go to school, standing at the bus stop. They're looking out the window all night long. We have experienced heinous abuse since I was a teenager, and this man was nearly 40 at the time. He has gaslit me, manipulated me, broken me down mentally, physically abused me, completely ruined my life. I single-handedly raised our kids with no child support. I am not on Medicaid. I am not on SSI. I am not on all these false allegations that he claims. I have single-handedly raised these kids myself. He never submitted his court-ordered drug tests to implement his parenting time. He never complied with all.
So you're talking about in the circuit court, right?
Okay, I'm sorry, I'll get to the point.
Don't take your time. I just want to make sure I'm understanding.
Yeah, so he never did what he was supposed to the entire time. My kids are grown now, and my son is in high school. He's never protected or provided for this family. They're both medically fragile, and he's purposely hindered them from being on Medicaid. He's purposely hindered them from being on SSI. I have taken every hit from this man, and I've never retaliated. I endured so much mental, physical, and emotional abuse.
Why does she talk like that? I can't even listen to the substance. Just that pattern, that voice pattern is so distracting.
It's completely breaking me down. He has attacked me, my family, my race, my sexual orientation, my partner. He has asked if we're still alive. He is creating so much fear within my children that they don't even want to stand at the bus stop. He's never been a part of their life. He's never been to the school. He has never taken them to a doctor's appointment. My son had cancer, Your Honor.
Okay, fine. I get it now. I get it. I'll summarize.
No, because I'm telling you the truth. I'm very gay now, and
He went to jail multiple times during his bone marrow transplant. Okay? He has been estranged from our family for years, and I periodically allowed him to see the kids at Christmas and different holidays where I thought he might not be high and that my kids
might be okay enough to see him for his little couple parenting hours, but he has become so heinous. He has escalated this violence to the point where I can hardly stand here and testify, holding myself up with this wall, and I'm trying to be strong for my kids. But when my kids can't stand at the bus stop, and they're too scared to go to their soccer game, and they're too scared to go to their karate because he might be standing outside of it, he was warned multiple times that this was going to be harassment. Detective Remy went to his house and warned him, okay? He still decided to do this after that warning. Once he was criminally charged, he still continued to harass me, stalk me, intimidate me. I took a picture of this man outside my son's karate, which my son won't even go back to anymore. I made another report in Trenton, but we didn't go through with those because we didn't want to add on to this. He is heinous. He's evil. I'm in church. He's sending me satanic messages, words that I can't even repeat in court, 40 back-to-back messages, none of which were child-focused. He's leaving me voicemails to the point where when my phone rings, my kids jump out of their seat. They're terrified of him. I'm terrified of him. And I'm going to sit there for 2.5 hours with this man. And just force of control. This abuse and domestic violence is going to end today. I can't be up for my kids.
Yeah, for the record, you lost me a long time ago.
You might be able to treat me like that, but these boys didn't need to endure this. And they heard those messages. They heard those voicemails. They went into my room, sleeping at night. They said they couldn't see what Dad said. They're staring out the window all night long. I'm having to pick up from school early because of pain stomachs. These are straight A kids. These are medical professional kids. I'm terrified of you and any part of a relationship that you thought you could possibly restore within these children. You tried to destabilize the very foundation I've set forth for them. I've never asked you for a dime, Dan. I've never asked you to show up or do anything that a father would protect and provide for an individual, and you have berated me. Within the community, I'm embarrassed to even be here. I know some of the people in this courtroom right now. This is embarrassing. Your children deserve better. You have abused me since I was a teenage girl.
Were they married?
You've manipulated me, gaslit me. You have physically abused me, and I've never recorded half of it. You've thrown me down the stairs, and the way you treated me when I was pregnant is heinous.
Think she's available, fellas. I mean, she's not interested in you, but I think she's available.
I'm sorry that I'm this upset, and I tried to maintain my composure, but the things I endured, and in those messages, I never once said anything ill back to him. I never once said all the things in my heart that I wanted to say, and my children said, Mom, please go to the police. Please go to the police, he might kill you, and then who's going to take care of us? And that's why I'm here, because if he does something to me, who is going to take care of my son who had cancer and he's getting all these infusions and medications? This man has tried to manufacture evidence that doesn't exist in the last couple of months by trying to...
I think these kids can make it.
Love, exciting and new.
Provoke me via text message to portray me in a negative light for family court. His evidence doesn't exist, and the truth always comes to light. He has tried to provoke me by attacking my family, my kids, everything, just to get a reaction out of me. He has been to jail. He has done probation. He's been to inpatient. He's been to outpatient rehab. Nothing is stopping him. Every punishment has been proven to be ineffective. He's been to jail for everything. Service. I mean, what is going to change him? He's almost 60 years old. I'm almost 40 years old. I'm standing here shaking. I'm embarrassed for myself. I'm embarrassed for him. And I don't hate him the way that he thinks. He hates me more than he loves his children. And I'm standing here because the Lord Jesus Christ sustains me.
How do you ever let that delicate flower go? Look at Judge Dad.
Anything else?
Anything else? You done?
Not true.
Anything else?
Nothing but to emphasize that clearly this is a matter that needs to be worked out in family court, whatever allegations she stated. They're very troubling. My client is troubled by them, but he can't speak. We don't speak to the veracity of them. Now, he's taking responsibility. He said he's sorry for the poor behavior. Is the subject of this case. And Your Honor thinks that this recommendation is appropriate for the evidence that prosecution set forth in this matter. And he'd just like the opportunity to move forward and proceed with this case in family court and get this worked out the way that court believes it should be.
As it stands, as I understand the order, he has to drug test in order to see the children.
We did one and he never submitted anything else. He's supposed to also pay half of all my children's medical bills. He never did.
Okay, I don't want to talk about that payment yet. I want to make sure the judge's order you're telling me says,
The part of the parenting plan says in order for him to see the children, he has to complete X, Y, Z, and it's gotta be supervised and all of this stuff. This isn't a family court issue. This is domestic violence. This is criminal court.
no, I know, but I just want to make sure there's nothing I can do here, and it doesn't sound like there is. The circuit court, well,
Children, anything to keep them away
but
from.
the circuit court doesn't have that order in effect though, do they? I can't start sticking my nose in children's issues. This was
Maximum punishment and that you deal with him aggressively because there's been no punishment in the past that has been proven effective at this point. He's been in rehab, he's been to jail, he's been in and out of rehab.
let me ask you a question. I'm not seeing any conviction for any reason since 2000.
And whying that,
Is that true or false?
Walking into his neighbor's houses naked and he was high on drugs. He went to jail twice, while my son was inpatient at Children's Hospital, for whatever substance related abuse charges that he, was doing. I couldn't tell you the exact charges, but
That was back at the beginning of the Swingers Club, and it was, things are out of hand then, but they've gotten it in order.
that is true and that is, provable through a FOIA if you requested that.
See, all that should be on his criminal history, and all I'm telling you is I'm seeing a 1992 operating while
No,
intoxicated.
sir.
I'm seeing a 96 ordinance violation of some kind out of this court. Maybe you can check that, Heather. And then, hang on one second. And then a 2000 unlawful bodily alcohol content, they used to call it, operating while intoxicated, again out of this court. But I'm not seeing one thing in here subsequent to that.
It would have been probably around somewhere between 2011 and 2014 or 15. Somewhere in that time when my son was sick, he did go to jail twice in Wyandotte. Went to jail twice. My dad went and got him. We paid the bond. At that point, we were still married. So
Is that true? Did you go to jail in Wyandotte twice?
I don't recall, Your Honor.
And Your Honor, I mean, even if he was, Your Honor, I mean, it's innocent to prove guilty, no charges came up.
Well, wait a minute, slow down. Hang on. Yeah. Sometimes if it's a 90-day misdemeanor, these might not make their way onto his criminal history. That's all I'm pointing out.
Sure.
And they're not on his criminal history. So that means one of two things. The judge, if it was less than a 93-day misdemeanor, the judge may not have ordered printing and photographing. If they did, then it would have entered up on his criminal history if there was a conviction. If they didn't, then we don't know enough to be able to say.
Your Honor, to the extent that there's anything to these allegations, I point out the time period you're talking about is 2014.
I get
12
it.
years
I get
ago.
it. I get it.
In 2015, he went to inpatient rehab, in Oakdale Rehab. That was 2015. My second son was 3 months old at the time, and my other son was going through bone marrow transplant treatment.
Your Honor, my client will not deny that he's had trouble with drugs in the past. He's got certain serious mental health issues that he's
I get
getting
it.
help with now.
I get all this.
Doesn't allow me.
I get all this, but you have to understand something, both of you. I cannot sentence somebody, ma'am. I cannot, in good conscience, sentence anybody on things that are allegations that were not proven. Please listen to me. You said you wanted me to give him the maximum. There is no way I can give him 90 days based on what I've heard here and based on, I just want you to understand. In the convictions, if any, are not part of his record. So if there was a conviction since 2000 at any court, in any place, it would be reflected on his criminal history. Please listen. So I want you to understand that there's an element of fairness to this process. It's most important, and that is that there has to be fairness, right? On the other hand, too, sir, you have problems. I mean, what did I read? You sent a picture of a dead mouse to her and said, "This is you," or something like that.
No, it's different.
Listen, well, this is what the officer said. I mean, this is what the officer said. You are a piece of S, you effing C. Calling WPD welfare check, something bad I don't even want to repeat in here. She's asking you to stop in May of 24. You sent a photo of a dead mouse in a trap with a follow-up text, "Gotcha." If you spend half the time, it seems to me, trying to get yourself some help and trying to do something productive and trying to make your relationship with your children better.
Behavior in this case is disgusting.
You wouldn't be here and your life would be a lot better. Now, I understand. I heard her. I hear you. But to me,
I understand the impulse after listening to her for the last 20 minutes. However, you can't do that.
the things I'm reading here are disturbing. And I'm not going to go back. I want you to understand something. I'm not going to consider anything other than your record and what has happened here because it's not been proven in the court of law. That's the good news. The bad news is that if I find out you're contacting her in any way, in violation of my order, I'm going to give you the maximum. You still can go get a PPO if you choose to. You might want to consult with a lawyer about what process to take. But sir, you seem out of control to me. You definitely seem out of control to me. You might not think so. I bet that you don't think so. It's okay. I just don't know why you would be acting like this. You have children. They are the single most important thing. They should be in your life. More important than you or your hatred of her or anything else you're doing. They should be more important to you than anything else in your life. And here you are, you're not seeing them because you're not drug testing in violation of a judge's order, it sounds like. And that's a whole different issue. You want to go your whole life, not know your kids, continue on this journey. Simple. It really is simple. And I'm just one of those old guys that happens to think that we need two parents in our lives. I think it's hard enough with two parents. So if one parent is shirking their obligations and responsibilities and not doing what they're supposed to do, there ain't no way, no how, nobody is going, I don't care who they are, that's going to convince me that that child or children are not affected. I don't care who it is. I don't care how much money the other spouse has that's raising them. I don't care who it is. That's, if you don't want your kids to turn out, keep doing some of the things you're doing. Now, probably just talking and it's going to go in one ear and out the other. It's your children, not mine. I think that's where we've gone wrong. People don't think about that anymore. I yearn for the days of Ozzie and Harriet. Leave it to Beaver. 18 months probation. I'm only going to charge you like it's 12 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. I really have no basis to believe that it was used, and I don't order that in this case, but there's enough here where I'm ordering it. But I'm not going to order. I'm going to order you to submit to chemical testing, PBTs and ETGs on demand of probation. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to continue your treatment at the guidance center. You're not to have any contact with Desiree Musso. You're not to possess firearms. When I say no contact, I mean you're not going to write her, phone her, see her, text her, email her. You're not going to do any of those things. When you comply with the orders of the circuit court to see your children, then you're going to go back to that order. And I'm going to say here specifically, unless in contact, unless, so no contact with her, unless in conflict with order of Wayne County Circuit Court. So I'm just telling you, if the order would permit you to, then I'm going to allow it. But otherwise, if you're just playing games with her and harassing her and threatening her and saying these nasty things, you're going to go to jail for 90 days. You're not to possess firearms. You're not to possess dangerous weapons. You are to serve 100 hours of community service. 100 hours of community service, and I'm going to give you until September the 1st to complete that. I'll actually make it September 30. We're going to have review hearings in this case. Again, you're going to continue your treatment at the guidance center. I'm going to go light on the fines because I don't think you have any money. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4. Probation fees are $240 because I'm reducing those to from $360. So your total's $565 plus the screening fee of $60 for $625. And we are going to set review hearings every 3 months, Heather, on Woodhaven dockets. Review hearings to be set every 3 months. I want you to go down the hall. We are going to give you a notice. If you think you're prepared to give me those dates now, Heather, you can. I'm going to have you take your time though. I'm going to have you pay $75 per month. I'll start that beginning on July the 15th and the 15th of every month thereafter. Now I'm cautioning you. Like, find out your contacting her. Unless otherwise permitted in accordance with that order, the Wayne County Circuit Court for that sole limited purpose, because I don't have the order in front of me. You're going to go to jail for 90 days. Do we understand one another?
Understood.
You have 21 days to appeal this order, 14 days to apply for a court-appointed lawyer for purposes of appeal. Review hearings to be set every 3 months. If you need time, Heather, I'll be glad to give you all the time you need. Go
We
ahead.
could probably do them. I
Go
could
ahead.
probably count them out. Well, the first one will be September.
Okay, September what?
We'll do September 16th.
At 8:30 in the morning, and you're welcome to come. And you tell me if he's violated the order in any aspects. And if there's any different violation that occurs in violation of these orders, you're going to call up and speak with the probation department and or the police department from Woodhaven. September 16th at 8:30. I'm not going to order this impulse control program I just want you to continue your treatment at the guidance center. We understand one another.
Understood.
Okay, when's the next one? December what?
December 23rd.
At 8:30 in the morning. And you give me one more, that'll be good enough for now. So that'd be like
That'll be
March.
March, and then we'll do March. Let me see, if we're doing the 23rd, then that'll be, just gotta count out what would be Brownstown. What day's in Brownstown? We'll do March 17th.
At 8:30. Those are your 3 review hearing dates. We're gonna give you those. You're gonna meet with probation. Do we understand one another? You understand you're out of control, right?
Understand?
Do you understand that?
Yes,
No more.
I will.
Go do it. And I'm telling you, I will not be anywhere near this time. Good luck. Thank you. Thank you. Okay, stay seated, please. Court is back in session. All right, people against, wait out there still. Amber Lynn Matisse, 24B1475557B.
Good morning, Judge and staff. John Graziani here on behalf of Amber Lynn Matisse. Ms. Matisse, to my left, please identify yourself.
What is she going to do on this?
Judge, she intends to plead guilty of violence.
Is that right, ma'am?
Yes, sir.
That's what you want to do?
Yes, sir.
If you plead guilty here, since you've absconded, you could get the 90 days. You understand that?
I do.
Did you sign, read, and understand the advice of rights form here today?
Yes.
I'm gonna need for Jessica on this.
Jessica's out.
Yeah, I know. So just tell them whoever's available, probably. If you plead guilty, you're giving up all those rights and we're not going to get a hearing. Do you understand that? All right, to the charge to be able to refrain from consuming alcohol or drugs, testing positive for marijuana on October 16 to 25. How do you plead?
Yes.
Did you test positive for marijuana on October 16 of 25?
Yes.
Had you consumed marijuana, say within a week preceding that date?
Yes.
Anybody forced you to plead guilty?
No.
Your plea is accepted to that charge. There's only one count. You only had 2 prior technicals, but again, because this was an absconding, she could get
Understood.
90 days. All right, let me check something here before we're gonna get probation in here. What kind of controlled substance was that again? It's not on the citation. Why didn't she show up here? Can you tell me?
Judge, she just became nervous and overwhelmed. I had a good deal of time talking with her, and she has tremendous responsibilities. She is the mother of 5 children, and she lives,
Are you married?
Is this a guy who got sucked into translating Spanish and then mostly spoke Italian, but still kind of helped in an odd way?
Married?
She is not married. She is living with her fiance. She's essentially a stay-at-home mom.
How many children have you had by how many?
It's just 5 children with this gentleman. So,
Okay, you just haven't been married,
Yeah.
but you live with him.
Yeah. I'm sorry, Steve.
who gets married anyway these days? Although I believe.
I'm waiting on.
I'm taking the fifth.
I'm gonna toss.
I'm waiting.
No, but no.
All right.
She suffers from schizophrenia, PTSD, severe anxiety, major depression, or manic depression, and she's overwhelmed, and she doesn't didn't have the courage to show up. And again, this is a situation where we're asking for mercy, Judge. She hasn't taken steps to take care of her mental health. She sees a therapist 2 times a month, in addition to a psychiatrist that's obviously taking her medications. And we're asking, in lieu of any jail time, that she be given additional probation. It's my understanding that she has a separate charge that arose Flat Rock, which was public intoxication. No, it was originally public intoxication. It was reduced to disorderly.
I think so.
Okay, it appears it was reduced to disorderly. That's a non-reporting probation, and anything that's given charge, I hope, coincides with that separate charge.
Ms. Wilds, your name?
That's with probation, Your Honor.
Anything you'd like to say, ma'am?
I am looking.
No, I was asking her for.
Oh, sorry, Judge.
Just, I apologize for waiting for its time by not showing up and. Really apologize.
What had she done and not done?
Yeah, Sharon, I'm looking at Miss O'Donnell's notes. She did complete 34 total hours of community service. I believe she was given additional hours of community service for her first violation, which was a positive chemical test as well. There's proof that she attended some treatment, but not completion. So there is at least progress towards treatment, but again, no completion. Testing is kind of what you see there, Your Honor, as far as her being violated with a confirmed positive on this violation and a prior violation as well. I'm not sure if monies have been paid. The last communication that Ms. O'Donnell had with her was back in September 25.
She has 5 kids. I just can't.
Before I think Ms. Matisse absconded. And I did not have a chance to look, but there is a note here that she was sentenced on that new charge in Judge Hessen's case on the public intox, but I did not get a chance to see what those terms and conditions were.
Okay.
Judge, she does owe money, but she has indicated to me that she's completed, that other program,
The,
the counseling.
Who's Jerry Knudsen?
thank you, Dan.
He posted, first of all, I need a first page of a register. And can you pull on? Yeah, but you never showed up on a case out of, Taylor, an assault case that emanated from January, that, let's see, I don't know when it occurred, but
Yeah, I didn't.
hang on one second. You got a warrant out of Taylor since January, I'm sorry, Lincoln Putt, since January 12, 26 on an assault case, simple assault.
I don't know what you're talking about, Andrew.
Judge, I was not aware of it, sir.
That was.
That was what?
Did you have that charge?
You didn't show up and you got a warrant out for your
I'm trying to figure everything out. I called up there and they gave me the walk-in days that I can come in and do. To go figure that one out.
Take care of it.
Take care of like everything that we've been trying to do is to take care of everything. So I'm looking away from my 5 kids because I'm the only person that can take care of them. The dad has to work so he can make the money to take care of them. They don't have like a.
Judge,
This is why you don't get married, people. According to her, this man had 5 children with her. Probably pays for all of it. And this is what you get. A loon that wants to go to the club and ignore her children while you run around and pick up the pieces. And people wonder why men have quit. It's not a mystery.
very briefly.
Let me just say this before we go on. I have no choice but to revoke her 7411 status and enter the conviction. Now I'm going to re-sentence her. I'm going to listen to whatever you have to say.
Judge, this is why it's.
Lucky for him. All right. At least he was wise enough to not marry her. But I mean, he's on the hook for all the kids. And that's what she's doing. She's probably getting child support for all of them and then partying all the time while she ignores them. That's what we're dealing with.
That I get where you're coming from. However, I mentioned, however, this young lady has so many issues that.
Married or have multiple kids, whatever. You've got all of his money at that point. And she in either one of those scenarios, she's a complete embarrassment to you and financial drain. That's what we face as men. I'm just being honest.
That have to be addressed, and she needs more extensive counseling, responsible medications. I asked that you continue the 7411 status, Judge, because again, she's been overwhelmed. She had in addition to all the issues she's gone through, she had a mental breakdown in the past 6 months, which when her husband was off work, she went to live at a motel just to get away.
Of course she's having a mental breakdown because she has 5 children that she's ignoring. And it's unnatural while she's out abusing substances. Of course. It will make anybody insane. If you can do that and not go insane, you're a psychopath.
Away from all the stuff for about a week. So I hope you understand what she's going through emotionally. Again, she was wrong for what she did, but at the same time, there's extenuating circumstances. I mean, she's 28 years old, has 5 children, and it is balancing. What a tremendous balance.
Judy, I don't think you get the plan here. The kids are her income source. She will crank them out as long as she can.
Balancing that, Judge. That's all I'm asking for. And obviously, no judgment, sir.
Glad you got that in there.
That takes full responsibility for all my wrongdoings. I'm just trying to make it right now. And I'm sorry that I wasted your time not on the man.
I don't worry about my time. I don't know why everybody seems to be worried about my time. This is what I do for a living. I'm not worried about the time. How many hours of community service has she done?
She's complete 34.
It shows a concerted effort to try to take care of things, Judge. She's
So if I send you for a drug test right today, right now, what am I gonna see?
Just my prescription from.
There's gonna be nothing other than that's which has been prescribed by a physician.
Yes, ma'am.
but she did indicate the marijuana, Judge.
Why are you staying with marijuana if you're pregnant?
Well, no, I haven't smoked in the last couple of days, but
When did you come down pregnant?
I just found out like 2 days ago. I miss him.
Who's the daddy?
And I'm TMI.
I don't need to get too in depth on this, okay?
I've been telling them that it would be without self-care. But I do not have the money to take the test.
What's your husband do? I'm sorry, your father.
He does construction.
Sounds like he's on the labor's council with the highway for the judge.
Yeah, we just haven't paid it. We found out the DTE, so I know I don't have money today to just pay it. I'm sorry.
Her attorney trying to shut her up with his hand.
I don't want to get too in depth. When you had, did you go into to a mental health facility?
She did not go into a mental health facility. A friend of hers suggested that she go get away, not to do anything stupid, but to get away like a lot of people need to when they're having a heck of a difficult.
How long were you in this hotel?
For like, what was-
What did you do when you were in the hotel?
I just relaxed and like tried to figure out my life, you know, like I relaxed, like trying to get in my head, you know, I get overstimulated really easily.
Come on, Judge, just ask it.
Ma'am, are you a whore?
Just rather than say the one part.
She's overwhelmed, Judge.
I don't need you to go into any more depth.
My schizophrenia was back up with it. That's as far as it.
I think I see what's going on here. A blind man can see what's going on here.
Try to go over.
Why aren't you getting yourself some mental health treatment?
I do. I work with a therapist twice a week, and I go to a psychiatrist once a month. Not twice a week, twice a month, and then I go to a psychiatrist once a month.
How long you been doing that?
For the past, I did ice cream back up Florida, but I quit for like a year. Then I thought I made something better, but it obviously made myself worse, and I started back. But so far, I've done therapy for like 4 years.
And how long, are you telling me consistently you've been at it 3 times a month between the two?
Yeah, consistently.
When's the last time you went to either one of them?
My psychiatrist, I just seen him on the 8th, and my therapist, I just seen her on the May 22nd.
What is that?
I don't know what that was.
Sounds like a train, another train.
Man, I think it was.
I'm gonna still revoke her status.
Thank you, Judge.
I'm gonna give you 4 days jail I'm gonna give you credit for 4. You gotta promise me you're gonna keep going to those 2 though, okay?
Going to,
Yeah, the mental health treatment and your psychiatrist.
people
She
swear.
needs more time.
You gotta get your life in order, okay? All right, that's it. I'm closing the case. You can tell your father of your children.
He just wants to get rid of her, which I don't blame him.
I gotta think this through again. They changed everything. I think they get the whole thing back, Heather. Mr. Noobsy will. I don't know. You know, it used to be 10% and they changed that and there are never enough changes. I just give them all the money back. I don't think we're supposed to keep any of that. Okay? So you could tell the father to call up to the court and he can dial extension. What's yours, Heather? 234 or what is it?
228.
671-0201. Can you write that down for her?
I am, Jeff.
Extension 228. You can talk to Heather and she'll tell him how to go about getting this. Okay?
Thank you so much, sir.
Good luck. Thank you. Robert Thomas Boyd, 25BA2557. Ms. Foley Carter, your appearance.
Foley Carter, Basman Township.
Your appearance, please.
Rob Harris can be at the Bronson Township Board.
All right. And Mr. Boyd, your name.
Robert Thomas Boyd.
All right. Mr. Crawford, your appearance, please.
Morning, Your Honor. No kill call, Jackson. Federal.
All right. What are we going to do here? Tell me you got good news for me, please. Tell me you got good news for me, please.
No, last time we were here, Mr. Boyd was ordered to complete the sentencing order in its entirety. He has made some progress. Unfortunately, if we were to go line by line on that sentencing order, he is not compliant with all but the winter storage of the pumps because we're in June. But otherwise, we're not there yet. We do have updated photos. I don't know if this court wanted to see them.
I do, but Mr. Boyd, I want to ask you a question first.
Yes, sir.
You don't have to do this. We've been going round and round on this since June of 25. Hang on one second. I don't believe I've ever revoked your status either. So I'm almost inclined to have to do that today if I'm going to give you more time. You don't have to do what I'm going to tell you to do, right? I'd like you to call your 2 sons and have them Zoom in.
Pardon?
Have them use Zoom
Oh,
to Zoom into the courtroom. Will you do that for me, please?
all my,
Call your 2 sons. You have 2 sons.
yes, sir. They work,
I know. They,
12.
so do all these other people. They're Zooming in from work. I'd like you to go out. You don't have to. I'd like you to go out. I'd like you to call them. I'd like to have a conversation. You are forcing me to do something that I don't want to do. You're refusing to take help from people that have offered assistance. Sir, I don't want to debate this. You're a likable man. They've been playing with this for 25 years. I'm frankly to the point where I could be faulted for letting it go so far. You're just not going to listen to me. For whatever reason, I don't think you're being defiant. I dislike judges. I don't like, it doesn't matter to me what the reason. You're just not going to comply. So if I can't get some indication from them that they are going to go over there and help you and understand the severity of this, because I have this belief in my brain, and I could be wrong, that you really haven't discussed the seriousness of this with them. I would like you to go call them.
One works midnight.
I don't care. Good, he's off. He's off.
I can't call him this morning.
What?
He's in bed.
Wake him up,
Oh,
Mr. Boyd.
see what I can do.
Get them both on.
Well, the other one, we're not on much talking terms.
You never told me that before. I don't need to know the reasons why.
Yeah.
Call your other son, get him on. Please do that for me. We're gonna give him the Zoom ID. Will you do that for me, John? Give it to him, or Sadie, give him the Zoom ID and have them Zoom in, and I'll pass the case and we'll go from there. I'm gonna ask you to stick around a little bit, please. Thank you. You're gonna go out and call and call them?
Yeah, just wait on.
Go out and call, you're gonna call them. Call them.
Yeah.
Yeah, okay. Come on in here, Mr. Boyd. Who's your lawyer on this one again?
Crawford.
Mr. Crawford, come on up on this one. Robert Thomas Boyd, 25BA2557.
Do you want Ross on there?
I don't want to bother him if you're in front of Judge Hessen. That is not what my intent was.
Taller than Steel Tree, I don't.
Mr. Boyd, your name?
Robert Thomas Boyd.
Mr. Crawford?
Michael, representative, Mr. Boyd.
What are we gonna do with Mr. Boyd? Did you call your son?
Couldn't get hold of him, Alan. Just connected his phone to one of his leads.
He also tried calling his wife, his wife, and she didn't answer because she's at work.
I didn't know you were married.
No, his son's wife.
Oh.
Mhm.
What am I gonna do with Mr. Boyd?
I'm very sure, Your Honor, it appears to me that my client is doing every sincere effort that he can in these advanced years and the type of support he has.
No, he's not. I've given him too long. They've been after him for 25 years to do this. Mr. Boyd, I think it's time for you to go to jail, and I don't want to do that.
I don't want to do.
Why are you not taking care of this?
I took care of a whole lot.
Do you have the pictures that they had?
I don't have the pictures, Your Honor. Pictures.
Only if she's available.
But Your Honor, my client submits that he did get the boat removed. He got the trailer.
Yeah, but she just got done telling me it's about the only thing he's done that's on the list for him to accomplish when I placed him on probation 11 months ago. And they've been after him for 25 years.
He's on the way. I didn't get the opportunity
To talk with the prosecutor
You know it's all your fault.
to see if we put our heads together and make a lot of suggestions.
Well, I mean, this has been going.
I know.
He's not going to listen. You're not going to listen to him. I don't think you're being defiant of me in the sense that you're not basically one of these guys that comes in there and thinks he owns the place. But you're not being defiant. You're just, I think there's some issues here.
What the solution is, I don't know.
Well, the solution is probably, I just got to send him to jail, I think.
Well, unfortunately, when you come out, he's gonna be in the same situation.
I know, but they've been after him for 25 years. You know how many hearings I've had him here on? Guys, can I have your name and can you both count your appearance?
Caitlin Fuller Farm, Brownsville Township.
Rob Harris on behalf of Bronson.
Can you spell your last name for my recorder? You, Ms. Paris.
Harris,
Harris.
Harris.
All right, what are we gonna do? Give me the pictures, please. Let me see them. Did you show them to Mr. Crawford?
Earlier. I gotta say, at first glance, Your Honor, they looked a lot cleaner than the other pictures that were in the file. You know, brighter, you kind of see the property a little bit more. We can,
Did say there's progress, just
not as much as one would like, so.
He is making progress, though. Maybe a little bit, right? Looks like the Taj Mahal compared to before, even though it's, you gotta get the vehicles out of there. These are inoperable vehicles. What's this wood pile doing here in the middle of the yard?
When they stole my wood last, fall, I had to buy some more wood. I heat my house with wood. And, I didn't want to put it in the backyard because
If I give you 2 more weeks, you're gonna have this done.
Put up a sign that says, keep your hands off my wood. That's how I roll.
I know. What do you want me to do? Send him to jail?
I don't know, Your Honor, I know that this has been going on.
I know.
Yeah.
Ad nauseum.
all I've got left is the bushes.
2 weeks. During the review hearing, I can't believe, I don't know what it is about me. I mean, I really don't. I really should have been fed up a long time ago. I mean, he made me send him to jail. How many times you go to jail on this? Once or twice?
Twice,
For how many days?
5 apiece.
Heather, give me a date in 2 weeks, please, or whenever, 3 weeks before I go anywhere and and it's not on Judge Heston's docket. What are we gonna do? July the 1st?
So that, not on her docket,
I want it
It will
on my
be-
docket. This should be
your
on my
docket will be-
docket
July 1st for Brownstown.
at 8:30. Okay?
Can I just make a note
Yeah, he's got a soft spot for these old codgers. He just does.
about what needs to be done?
Yes.
Just so that he knows that it's.
Yes, absolutely.
So looking at the sentence, going by line, first, the 2 vehicles that are parked on the grass, they need to be on impervious,
I want you to listen very carefully to him.
must be located on concrete or asphalt driveway surface. They also must be roadworthy, so the flat tires on the RV and cars, those are not roadworthy, so they need to be made roadworthy. The garage was taken down, the permit was pulled, however, there's still no inspection, so it's not completed, so if you need to contact the township, have them get out there and make sure it's safe.
Do you understand that?
Yeah, I thought he was the guy I had to have come out and look.
Well, you can set it up with him right now.
No, I'm not the.
Yeah, I know, but can't you help expedite it by,
Absolutely, I mean, and also the cement's still there for the garage, the cement has to be, removed. So that, to get the permit to be passed,
right,
the cement has to be, so I'm not a building inspector,
right, I know.
but when I spoke with him yesterday, he said he would not pass it because the cement is still there, the broken cement.
I want to keep the cement there to park the stuff on.
The cement is broken, raised.
It's a cement floor from a garage.
I made the orders initially. You need to follow them and go back to the probation order where everything was attached. And then you prepared another order on this case, correct?
We did, Your Honor.
And it's attached to the probation order.
Your Honor, I also gave Mr. Boyd a copy the last time.
I know. See, you gotta follow that. You gotta read that. Get your son to help you. Get somebody to help you. But if they don't pass it, it's no go.
What's wrong with keeping the cement?
You talk to them about it. I ordered you what to do and I expect you to do it. 3 more weeks, that's it. I can't extend probation anymore under 771. You're coming to the end of the year.
Just to be clear, Your Honor, 2 motor vehicles all over the grass on concrete.
Correct.
Asphalt and roadworthy, and get the building, passing grade from the building inspector.
Exactly.
The garage.
There's a whole order.
There's more that's coming.
There is, yeah, so there's still junk, trash, rubbish, road garbage throughout the property.
That's pretty clear. You gotta get rid of all that
I am.
within 3 weeks. Go ahead.
There's no trailer storage, so there's multiple vehicles that are being used as outdoor storage. That can't happen in the township. As Mr. Harris stated, the cement needs to be removed from the garage demo because it's all busted up, so it can't be used as like a pad for parking. The grass and noxious weeds need to be taken care of. There's an ordinance where it's what, 6 inches?
It's 8 inches, but I mean, there's weeds there that are taller than me. especially at the side of the house.
You gotta get rid of them.
Yes, sir.
That's about it.
Home's done.
Get rid of it, please.
Fight over that cement. I have to have them to park the vehicles on. They ordered me to park the vehicles on cement. That cement is fine for parking the vehicles on.
Well, you haven't, he's not the building official.
I know.
He's gonna help you get in contact with the building official before you leave here. You
Yeah,
can explain that to him, and he's gonna come in here and talk to me in 3 weeks. If you don't resolve,
okay, we'll see what we can do.
let's get it done. Can't believe I'm not sending you to jail, Mr. Boyd.
Thank you, Your Honor.
Your Honor, I appreciate your benevolence.
Good luck.
This is 54D01, 2601 F6209, State of Indiana, Samuel Thorne. Could you state your name for the record, sir?
Samuel Isaac.
Okay, so apparently Biggin's not on, and we've got like hazardous weather advisories everywhere, so I can't leave the condo anyway. Usually I ignore this crap, but I ignored this yesterday, and it damn near killed me. I walked out today, there's like branches everywhere. They're like beach chairs flying off rooftops, and I mean, the city's a mess. Like, no kidding.
Thorne.
The record should reflect the defendant appears in the custody of the Montgomery County Jail by video for initial hearing. How old are you, sir?
I'm 35 years old, ma'am.
How far did you go in school?
Say it again.
How far did you go in school?
I graduated diploma.
From high school?
Yes, ma'am.
You read, write, and understand English.
Yes, ma'am.
At the time these charges were filed, the state had an address for you of Pasadena, California. Is that still your address?
No, ma'am. I don't live there no more.
What is your address, sir?
I don't have a current address right now, ma'am. I'm right now. I'm living out of my truck. Well, I was living out of my truck till this matter happened.
What is your email address?
.com.
What cell phone number do you use for text messaging?
323.
Do you suffer from any mental illness?
No, ma'am.
To your knowledge, do you have a history of any mental illness or emotional disability?
No, ma'am.
Are you today under the influence of any alcohol, drugs, or other intoxicating substances?
No, ma'am.
You received a copy of the charging information.
Say it one more time.
Received a copy of the charges.
I have a copy of my original ticket that I received in my phone is possession of marijuana, and that was it.
Okay, we've sent a formal copy of the formal charges to you down there to the jail. It's a white sheet of paper. It says information at the top with 2 charges on it. Count 1 being resisting law enforcement, a level 6 felony. Count 2, possession of marijuana, a class B misdemeanor. Count 1 reads as follows. On or about January 14th, 2026, in Montgomery County, state of Indiana, one Samuel Isaac Thorne did knowingly flee from Robert Heckinger, MCSO, a law enforcement officer, while said officer identified himself, or after said officer identified himself by visible or audible means and visibly or audibly ordered Samuel Isaac Thorne to stop. And in committing said act, Samuel Isaac Thorne operated a vehicle.
I don't know what the hell you're on about, but that's definitely not the case.
Count 2, on or about January 14th, 2026, in Montgomery County, state of Indiana, one Samuel Isaac Thorne did knowingly or intentionally possess marijuana, pure or adulterated. Those charges are signed by Andrew Salter, Chief Deputy Prosecuting Attorney. Do you understand the charges you're facing, sir?
I do not, and I have and may I add my truth or affidavit? If I'm not because I had wrote my affidavit and I had sent it up on Friday when I was home when I caught all these Greyhound buses to come up here to deal with this matter.
Okay, I'm not taking any affidavits today. The purpose of today's hearing is
Excuse me, ma'am. I'm asking, did you receive my affidavit? Because I sent it up Friday when I was home. I was home last Friday. I got up here. I came up here.
He's got to work on his verbosity. or whatever. I can't remember what the made up word was yesterday. If you didn't see that on Vlog Talk with Mike, that pro se trial was delicious. The guy was talking just like this.
All my way from California to deal with this matter. On January 14th, I wasn't arrested at all. I was cited a marijuana ticket. That's it, ma'am. And I was told to go. I was told to go on by my way. Now, and that was about it.
You were given a court date to appear on February 26th at 9 a.m.
And that I didn't have no recognition of, because before the charge was even in the system, whether or not I was trying to deal with the matter, I was trying to pay the ticket for the marijuana. And again, I'm not on probation, I'm not on parole, anything like that. So there was no consent for the officer to search my truck or anything like that. And on top of that, I never fled from the officer. I never what you call that? Resisting arrest. I'm a Class A driver, ma'am. I have no felonies, anything like that. I drive trucks for a living. That's about it, ma'am. It was now the resisting arrest, anything like that. That can possibly never happen, because I would have went to jail January 14th that night. So that's why I came all the way from California to deal with this matter, ma'am. I caught all the Greyhound buses to get up here. I have no more funds to pay any fee, whether or not, but I wanted to do my due diligence and come up here and deal with this matter, because I am not what that paper says I am. You know, I'm a Class A driver, ma'am, and that's all I do, ma'am. I go to work and that's all I do, ma'am. I don't do nothing else. I'm a Class A driver and I'm from California, ma'am. I'm not from up here. I don't know the rules and the laws up here. So that's the error as well. But yeah.
Mr. Thorne?
Yes, ma'am.
Stop talking.
Say it again.
Please stop talking. The purpose of today's hearing is to advise you of the nature of the charge.
Shut your hole. Oh my God. You know, over time, I've always gotten irritated with these guys. And as I get older, I'm starting to think they just, you know, a good segment of the population is just too stupid to function. They just are. I'm actually starting to get empathy for them. I don't think that's an act. I think this guy's tremendously low functioning. The end.
Charges against you, the possible penalties, and your constitutional rights. I understand that you may not agree with the charges, but do you understand what you've been charged with?
I acknowledge.
Do
you understand the charges?
I acknowledge the charges, ma'am.
No, I get it. And like, I didn't piece it together. Yes, that was what he was trying to sell. I took it literally, and I'm like, yeah, that's not the way it is, which only confirms the joke.
That's not my question. My question is, do you understand that you've been charged with resisting law enforcement, using a vehicle as a level 6 felony, and possession of marijuana as a Class B misdemeanor?
I don't even know how to. I don't know.
I'm asking if you understand what the state is charging you with.
Yes, I understand what I am being charged with.
Count 1 is a level 6 felony. It is punishable by a sentence to the Department of Corrections of not less than 6 months, not more than 2.5 years, with an advisory sentence of 1 year. It also carries with it a maximum fine of $10,000. Count 2 is a Class B misdemeanor, punishable by up to 180 days in the Montgomery County Jail, a fine of up to $1,000. If you are convicted of Count 1, the conviction would be reported to our Bureau of Motor Vehicles. It would become part of a permanent driving record for you. It counts towards habitual traffic violator status because it is a major traffic violation in the state of Indiana. In the state of Indiana, if you accumulate 3 convictions for major misdemeanor traffic violations on your driving record in any 10-year window of time, the Bureau of Motor Vehicles on its own would determine that you are an habitual traffic violator. Your driving privileges would then be suspended for a period of 10 years. Your driving privileges in this case could be suspended for up to 2.5 years. If you are convicted of Count 2, if you're charged again in the future in the state of Indiana with possession of marijuana, the state would file that new offense as a Class A misdemeanor, and the penalty would become more severe. Do you understand the possible penalties you're facing in this case, sir?
Yes.
You have certain constitutional rights that you carry with you throughout these proceedings. Those are your right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt to each element of an offense. You have the right to confront and cross-examine the witnesses against you, to see them, hear them, and ask them questions. You have the right to have witnesses appear, testify on your behalf, and to use the court subpoena power to make them come to court. You have the right against self-incrimination, or what people commonly call your right to remain silent. The fact that you don't answer or that you don't testify cannot be used against you. You also have the right to testify in your own defense. Should you choose to exercise that right at trial, you would be subject to cross-examination and your statements could be used against you. You do not have to call any witnesses or present any evidence whatsoever because the entire burden is on this state. You have the right to appeal any conviction to a higher court of law. That would include your right to appeal the terms of any sentencing orders. You have the right to be represented by an attorney. If you could not afford an attorney of your own choosing, the court would appoint an attorney to represent you. Do you understand those rights, sir?
Yes, and I would like to get a paid attorney if so.
Mr. Thorne, please
Yes,
let me
ma'am.
conduct the hearing. I will ask you questions and we will get through it, but we cannot both talk at the same time.
I apologize, ma'am.
Okay. With respect to your right to counsel, do you wish to be represented by an attorney?
Yes.
Intend to hire someone or are you asking for a public defender?
I need to hire someone, ma'am.
You're going to hire your own attorney? The record will reflect that you plan to hire your own attorney. I will advise you, Mr. Thorne, that you need to do that sooner rather than later. We're going to give you some court dates, and one of them is called an omnibus date. An omnibus date really is a date that triggers the filing of certain motions. Some of those motions have to be filed a certain number of days prior to the omnibus date, and some of those motions have to be filed a certain number of days following the omnibus date. Some of those motions would be deemed waived if they're not timely filed. So that's why it's important to hire someone sooner rather than later. Do you understand?
Yes, I understand, ma'am.
Court's going to enter a preliminary plea of not guilty for you. It becomes a permanent plea in 20 days unless after consulting with an attorney you decide to enter a different plea. Court's also obligated to set this matter for an omnibus date somewhere between 45 and 75 days from today's date. The court will set the matter for omnibus and status hearing on August 4th at 9 a.m. for a jury trial October 13th at 8:30 a.m. Absent further order from the court, sir, that's when you're ordered to be back. Do you have any questions about those dates?
Yes, I do. What is my bail amount?
You don't have bail. You failed to appear in court, so you don't have any bail. You're being held without bond.
Ma'am, and I totally understand that, but there was a reason for that.
Well, that issue is not being addressed today. The court today. If you want the court to consider setting, you can file something with the court so the state can prepare for a hearing. But at this point, you have failed to appear back on February 26, 2026, as ordered and as cited in your ticket. So the court issued a warrant for your arrest to be held without bond for your failure to appear.
Again, ma'am, man.
Do you have any other questions, sir?
Yes, I do. I'm just trying to redirect my question and make sure it's man, I just don't understand how I resisted arrest and flee in a big rig and not be arrested for it that same day.
Let me just tell you.
It doesn't make no sense at all, ma'am.
Let me tell you procedurally what happens. If the police have
not to cut you off, ma'am, especially hearing this matter and me coming all the way out my way just to deal with this matter, ma'am, like
do you ramble?
I would never evade or resist. I have no reason to resist.
Just let him calm down.
Yes, ma'am.
Mr. Thorne, here's what procedurally happens if you have an interaction with police. They can either arrest you at the time and take you to the jail, or they can file what's called a long form with the prosecutor's office. Either way, they're going to submit a report to the prosecutor's office. The prosecutor is actually charged with proving the case beyond a reasonable doubt. So regardless of what charges the officer initially charges you with, the prosecutor determines the formal charges which are filed in the court. So in this case, the officer gave you a ticket for possession of marijuana, but when the prosecutor's office received the report, they added a charge of resisting law enforcement against you. So that is what you're charged with. You've been muted, Mr. Thorne. I'm not able to hear what you're saying. If you're going to interrupt me, I'm going to keep you muted. You can unmute your device if you click on the little microphone icon in the lower left corner of your screen, but I'm not going to talk over you, sir. We have to go in and unmute him.
Why? I didn't mute nothing, man. I'm not touching the computer to mute anything. Do you hear me?
I muted you. I muted you because I asked you to stop talking and quit interrupting me. You wouldn't do that.
I wasn't trying to interrupt you, ma'am.
Okay, you don't want to interrupt the judge, whether it's me or anyone else. You just don't want to do that.
I totally understand.
So I understand that you are probably going to request a reduction of your bond or a setting of a bond. You can file something with the court so that can be set for a hearing. The court is not going to hear that today. Do you have any other questions, sir?
How can I get counsel for my paid lawyer? How am I able to do that behind you guys' bars?
That is up to you. You indicated that you plan to hire your own attorney.
I need to. Yes, ma'am, because I need to, because this matter right here doesn't make no sense and I need to.
Okay. You have the right to do that, but you'll have to make those arrangements. I'm not sure how to do that. I've never been in jail, so I can't answer that question. Anything else, sir?
Man. Man, bro, I don't know how to go about this, man. For the record, I am requesting for video and dash cam to be available as well.
There is discovery. It's governed by Indiana codes and local trial rules. And so once the proper paperwork gets filed, that automatically it gets generated in the prosecutor's office and sent where it needs to be.
So the affidavit that the officer was given. So my affidavit isn't qualifiable as well.
Your affidavit is in your file, sir. It was received
Okay, I'm just making sure that it was received, ma'am.
It's received. It's in the court's file, but the court hasn't done anything with it other than show that it was received.
So it wasn't looked upon?
No, sir. There's a proper way. If you want the court to address something, there's a proper way to do that. You plan to represent yourself, you have to follow the trial rules just like an attorney. If you want an attorney to assist you, then you have to hire someone to do that. You can't just file paperwork with the court that's not labeled anything, that's not a motion, that's not asking the court for something specific. Otherwise, it just shows as received paperwork, received correspondence. At this point, it's received correspondence.
It was the affidavit of truth.
Well, call it what you will, sir, and it says it's affidavit in the file, but it is what it is.
So that means the officer affidavit isn't an affidavit either?
Sir, you can't just file a piece of paper with the court and say that it's affidavit of truth. That's not how it works. The court doesn't take evidence through the through the mail for a case. That's just not how it works.
Wow.
I think you need to talk to an attorney, sir, so you can figure some things out.
This don't make no fucking sense, bro.
That is all for today. Thank you.
And then, Mr. Saptowski, there's another case, One Advantage LLC against Johnny, and I'm not sure if you pronounce it Dubois or Dubois.
Dubois.
Dubois, okay. Mr. Dubois, you may have a seat. And this is case 2508 CC 3395. I will show Attorney Ian Saptowski appears for plaintiff in person. Mr. Dubois appears in person for himself. This hearing was set on a petition of defendant. I have read through it, and I've read through the subsequent documents several times, and I'm trying to wrap my head around it because I didn't see a garnishment order issued yet in this case. But it seemed like there was a request to have some priority shifted relative to a garnishment order. Could you help me understand what you're seeking today, sir?
Well, Your Honor, you were asking me what made my senior debt senior over the junior debt, the senior lien. And so I'm prepared to give you that today, the reasons for which that my senior lien is senior to the junior debt. They haven't objected, so I have the floor. I think where you might be confused with regards to a garnishment attached to this, the garnishment that they found was attached to the employer through Title 4D.
Okay.
So I probably need 7 to 10 minutes to read because I've prepared a statement, if that's okay.
I'll hear you out, but I do want to ask, this court doesn't typically handle 4D garnishment orders. Those are handled through the family division.
I understand, sir, but at the same time, this court did order supplements to the garnishee from this court.
Okay. Can you give me a date of that order first?
There was a meeting date set for 11/14 of 25 that the garnishee failed to appear. Another thing would be this court dispatched supplements to the garnishee to be answered. So
I'll ask again, what date did this court issue an order related to post-judgment collection? Because I don't see one.
I want to say October 15th. It's in the CCS. They've got the CCS listed as decided.
So I do see the default judgment was entered on October 13th of last year.
Right, October 13th.
And then the plaintiff filed a verified motion for proceeding supplemental, and this court granted that motion and ordered a meeting, but it didn't order any garnishment. It just ordered a meeting.
Exactly, sir. I'm not suggesting that this court has put a garnishment in place. I'm asking that this court, I don't want to say put a garnishment in place, but order the mandate.
Okay. Well, when I look at your petition filed on it was filed on April 30th after hours, and it got filed marked the next day on May 1st. The title of it is Emergency Petition to Enforce Garnishment Priority. Now, I could be wrong, but to me, when I read garnishment priority, it would imply that the court has to juggle which garnishment is superior or inferior.
I would imagine it would be the garnishment that the court used to issue the supplement, sir.
I haven't used the garnishment to issue a supplement.
Who issued the supplements? They were sent to the plant. They were sent to the garnishee for a November 14th meeting.
Your Honor, if I may.
Yes.
Just to clarify a little bit, there was an order for proceeding supplemental, and that was set for a telephonic meeting on November 14th.
Yes.
But there's been no garnishment.
Well, I didn't suggest there was, but because.
So I think that's what the court's asking.
Yeah, I've answered the question, I think, twice now.
Okay.
With all due respect, sir.
Oh, and with all due respect, sir, I've told you now, this is the third time.
Yes.
Law Talk with Mike for hot collection law.
Sir.
I can't say this garnishment is superior to this garnishment if I've never issued this garnishment. Do you understand?
Mhm.
Okay,
I'm asking that you do issue a garnishment.
okay, and I will give you the floor to tell me why I should issue a garnishment
Are you?
or prioritize.
Okay, it might take like 5, 7 minutes, 10 minutes of reading.
I'll give you 6.
You'll give me 6? Okay, well, now you understand that the garnishee,
I don't know what happens here, but it's not going well so far.
failed to respond to this court's order, right?
Who's the garnishee?
His name is Josh Learman for Learman Electronic Tool.
I don't have a Josh Learman listed as a garnishee defendant in this case.
Can you tell me, sir, how that was established as the garnishee? Mr. Learman,
Your
and
Honor,
Learman Electronic Tool.
Your Honor, the garnishee is Learman. It's the company. It's not Josh Learman.
Right, it's Learman Electronic Tool, but he represents Learman Electronic Tool.
I don't know. There's a ProSep issued to Learman Electronic Tools, Your Honor. That's what was set for November 14th.
For what date?
November 14th.
Okay. And what did you learn around November 14th of last year?
Well, Your Honor, they had not responded to interrogatories, and so there was no action taken because there was no answer from the garnishee.
They've been in contempt for over 6 months.
Not in my court, sir.
Okay,
So
I understand.
I think maybe you filed in the wrong court. I'm gonna go back to my issue for the 4th time. I understand you're saying that a certain other garnishment is superior to a garnishment in this case. I have confirmed from my review and from plaintiff's counsel's review, there's not been a garnishment order issued in my case. So I can't put it before you or after you. It doesn't exist. So
Not yet.
Not yet.
Right.
But for,
Okay, so I'm prepared to read.
all right, I'll return to your time and I'll start the 6
And I'm
minutes.
reading this with the understanding that the supplements were sent by this court to, or were sent by the defendant, by the plaintiff to Mr. Learman's business, right?
I don't know what assumptions you have, sir.
Well, it's not an assumption. I pulled them right off the CCS, sir. I downloaded them from the CCS. They was processed by the court CCS, is what I'm believing.
Are you telling me that this court processed a garnishment order?
No, I'm saying the court sent supplements to the garnishee.
And I
That
don't
is
know
in
what you
another
mean by
case.
supplements.
Well, I'll let him explain, because he's the one who sent them. If you would, sir.
I don't know what you're asking.
You sent supplements to the garnishee.
Are you talking about the proceedings
What are you
supplemental
talking
order
about?
that was entered by the court?
Supplementals is what the CCS reads.
Okay.
Supplementals.
So, Your Honor, there was a ProSep entered by the court,
I don't know what he wants yet. I can't figure it out.
and we did send that out by certified mail to the garnishee. But our indication was that came back unclaimed to the garnishee, and so we didn't think we had service on the garnishee.
Oh, you had service, sir. If I can now, sir, please.
Let me first clarify.
Okay.
Just because someone has knowledge behind the scenes doesn't mean that there's official service that's been had. So if the record does reflect that there's not been service, it's come back unclaimed, that might not trigger the plaintiff's ability to do anything further, which it appears that's what the plaintiff was under the understanding of. But I would.
But their understanding was incorrect.
I don't think so.
All right, sir. Thank you. If you don't mind,
I'll
please.
go right ahead, sir.
Okay, the law of prior existence, unanswered concession is conclusively proving senior asset maturity. The petitioner presents this fundamental commercial reality directly to the court. A junior debt track cannot attach itself to a non-existent corporate liability. By executing their collection maneuvers in August and October of 2025, those junior entities provided the definitive historical proof that the petitioner's $300,000 senior sum certain asset was already maturing, active, and sitting immovably on the corporate ledger. A third-party debt collector could not have successfully attached a garnishment to the garnishee, but for the pre-existence of the garnishee's continued responsibility to the garnishment. The petitioner's actions stand as an absolute administrative admission. The senior asset was fully vested long before the junior debt attempted to intercept the funds. The anatomy of forced delay, the junior interrogatory conversion matrix. Because the junior debt's 2025 junior track establishes that the senior asset was already active on the corporate ledger, there is no question. Without the senior asset, there would be no garnishee to issue interrogatories to garnishee defendant for a meeting date of 11/14/2025. By applying the established public record directly to the specific unanswered line items of the garnishee defendant's interrogatories, the timeline of the senior liquidated debt is completely verified by their own silence. Line 2, employment retention status. The interrogatory demands whether the defendant receives periodic earnings as an employee. This is answered by the garnishee's own sworn admission on January 17th, 2025, stating in plain English, plaintiff was not terminated from Learman Electronic Tool. This continuous retention is verified by the Stark County Prosecutor's Title 4D certification, confirming that the employer never filed a statutory termination notice with the state agency. Line 3, date of hire and leave calculation. The interrogatory demands the date of hire and the duration and circumstances of any active leave. This is answered by the employer's official first report of employee injury, prepared by their claims adjuster on August 7th, 2023, listing the fixed date of hire as of September 23rd, 2021. This specific 2021 date anchors the priority of the senior debt by operation of law under IC 32-28-12-1, which commands that a corporate employee's lien relates back to the original date of employment. Furthermore, the adjuster's data entries establish that the petitioner was placed on a recognized legal medical leave status following a workplace injury on July 17th, 2023. Line 4, statutory wage baseline. The interrogatory demands the average weekly gross amount paid to the employee. The FROI face sheet documents this average weekly gross wage as $880 per week, mathematically establishing a statutory temporary total disability base rate of $586.08 per week under IC 22337. Line 6, active state support garnishments. The interrogatory demands the itemization of active garnishments orders currently in effect. The record documents active Title 40 enforcement tracks on this specific payroll account, including Elkhart Superior 6 juvenile paternity case, which remain legally connected to the employer due to their failure to execute their statutory reporting and payment tracking duties. Line 7, outstanding corporate indebtedness. The interrogatory explicitly asks whether any debts are due to this individual from the company. Because lines 2, 3, and 4 establish continuous employment and active medical leave on the payroll ledger, this line can only be answered legally by admitting the underlying administrative default under IC 22337. The corporation's failure to issue a written denial
Interrogatory?
within 30 days of actual knowledge of the injury operates as a binding, self-executing commercial admission of the debt. While the physical recording date bears a 2026 marker, the legal priority of this senior asset does not establish itself from the recording. Under Indiana Code Section 3228-12-1, the legislature explicitly commands that a corporate employee's lien relates back to the original date of employment. Because my underlying employment baseline with the garnishee was fixed on September 23rd, 2021, this senior lien occupies the absolute priority position on the corporate ledger by operation of law, predating the October 2025 junior debt by a full 4 years. Regarding notice of the garnishee to the garnishee, under Indiana Code Section 20.546, a corporate entity bears a strict non-discretionary duty to maintain its registered office address. The garnishee completely abandoned their registered 6th Street office over a decade ago, keeping themselves operationally blind. They defaulted on their own default. To ensure absolute integrity of notice, I forensically dispatched the authenticated master record via USPS certified mail. As the live tracking records from this morning confirm, a physical notice was left at their active facility on May 29th, and they have actively chosen to leave it unclaimed at the post office. Under Indiana Trial Rule 411, this continuous evasion constitutes a refusal of service and waives any claims of a lack of notice. Finally, Your Honor, regarding the complete legitimacy of the $110,000 medical allocation. This sum is legally classified as a liquidated sum certain under Indiana's doctrine of reasonable certainty when an employer completely abandons its statutory obligations, withholding the first report of injury and bypassing insurance channels. They cannot use the lack of a final hospital notice invoice to escape liability. The law permits me to establish a...
Okay, I'm going to break this down for you. This guy's a deadbeat. He doesn't want to pay his bills. They garnished his wages through his employer, and he thinks he's found a clever way out of it. It doesn't make sense because what he's saying is stupid. I'm just keeping it simple for y'all.
Evaluation based on the active documented directives of any of my treating physician, which was
In case anyone cares, that's what's going on.
prescribed by the employer. Lever electronic tool. This figure is derived directly from Dr. Matthew Bennett's formerly diagnosed M5116 disc disorder with radiculopathy and ordered decompression therapy. With $110,000, 30.
If you understood what was going on, it would be a bad sign because this guy is just making a completely pointless argument that does not make sense. The other guy is just, he's just there.
$6.80 represents the cap cost package to execute those precise medical orders over a full stabilization cycle. It is a conservative, non-invasive alternative to invasive spinal fusion surgery. Under Indiana Code Section 22-3412-1, a corporate lack of diligence carries a strict statutory liability corridor. Because the plaintiff blew past this court's May 21st deadline without filing a single objection, and because the garnishee has chosen total silence, liability and damages are structurally closed under the Supreme Court's ironclad Siebert-Oxydermo doctrine. The math stands completely uncontradicted on your docket, sir. The relation back priority is absolute. The record is fully ripe, and I respectfully request this court to immediately execute the ministerial mandate to protect my family from the further imminent harm that it's already suffered.
Thank you, sir. Mr. Sapkowski, your response.
Your Honor, with all due respect, they've already...
I'm sorry, sir.
Yes, sir.
I said, Mr. Sapkowski, your response. That means it's not your turn anymore. I gave you 8 minutes beyond the 4 minutes of dialogue from when I first said at 10:17, I'll give you 6 minutes. It's 10:29. Mr. Sapkowski?
Your Honor, my record indicates that the garnishee had not been served with the pro sep order, and so the plaintiff hasn't asked for a garnishment order. I don't know that there's anything before the court can rule on. Even assuming there was some question, I don't understand the theory about there being a prior garnishment lien. However, even if that's the case, I think that would be for the garnishee to figure out, and the garnishee would be the party on the hook and liable to determine which garnishment would be have seniority in that situation. But I think that the situation for the court is that there's nothing pending. There's no motion by the plaintiff. There's no garnishment order, and so there's nothing's ripe here for any adjudication.
Thank you. Mr. Du Bois, any reply to that response?
And that's why he's quiet, because he's so far off the path that there's nothing for the judge to rule on. He's making effectively an oral motion in front of a judge for a garnishment where that's not the appropriate place for it. Nothing is going to happen. The attorney knows it. He cannot follow his argument because his argument doesn't make any sense. Nor can the judge follow his argument for the same reason. Let's see how this unfolds.
I was just curious as to why it was they didn't file this response by May 21st when you ordered them to. They didn't file a response by May 21st. They don't have a response to give today.
And who's they? They didn't object, but that doesn't mean that whatever relief you have requested needs to be granted. It still needs to be valid. And what I'm coming back to, sir, is you're asking me to prioritize garnishment orders. And I haven't issued a garnishment order. So I can't say that my garnishment order in this case is inferior or superior for that matter. I can only say if there's another garnishment out there, great. Now, I will tell you, when I first received your information, I was under the impression of the blanket rule of first in time is first in line to get paid. And I saw a judgment entered in this case last summer. And then I saw a recording in 2026. And I actually issued an order along those lines, like it would appear it's later. However, I then did some research. I located your statute, some case law, and it does appear that if that a lien through an employer relates back to the first date of employment. So it would appear to be sooner. And I could confirm on the record with an order that to the court, it appears that the date of employment of defendant precedes the date of the judgment in this case. But I think that's as far as I can go. I don't think I can then say that this garnishment order is inferior, that as Mr. Saptowski suggested, if an employer or any other garnishee defendant gets two different garnishment orders, it's their responsibility to determine which one is superior and which one gets paid. So I think at the end of the day, my relief is the court has reviewed defendant's petition. The court at this point understands a little bit about what's being asked for. It appears that a determination of priority was requested. It might be either moot or not right for a decision today. So the court won't issue a specific definitive order of priority, but the court will indicate in its order that it does appear, based on the theories reviewed, that a prior judgment or garnishment order would need to eventually be enforced because it would relate back to the first date of employment of defendant. But again, I don't think there's any relief I can give beyond that.
To you.
Do you have any follow-up to that?
I do, Your Honor. I would argue that you could put a garnishment against Learman Electronic Tool today.
The only garnishment I could put against Learman Electronics today is a garnishment in favor of the parties, in this case, like a plaintiff saying, you, Learman, must pay Elkhart Superior Court 5's clerk for the judgment in this case. If I did that, and if Learman were confused, they might go ahead and pay on the garnishment to my court, which I see you have an issue with. If I don't grant a garnishment in this case, they're not going to have that confusion. And there hasn't been a request for it. It goes back to this. The plaintiff is allowed to send out interrogatories and file proceeding supplemental motions, and they're allowed to try to have them served, which it appears from my records that it's not been. But all they're doing at that point in time is asking for information. Here are like 3 interrogatories. Is the defendant employed? Are there prior garnishments? What's the amount of pay? Them answering that, or not getting served and not answering that, doesn't trigger any automatic garnishment.
I think we can establish, with all due respect, Your Honor, which is what your record already reflects, which is I have a senior lien over a junior debt because without my senior lien, they wouldn't have had anything to attach the junior debt to. Now, I understand for your court's purposes, they were attempting to attach this to the garnishee. Okay? Now that I'm sitting here with you, I understand your position. I would ask that you put the garnishment in right now to satisfy that lien. I'd have no issues with you doing that. I waive any sort of action as far as trying to stop you from doing that. If you want to go ahead and put a garnishment in against Learman Electronic Tool for their $7,000.
He's the judge. He doesn't sua sponte enter garnishments. Oh my God, this is all just so stupid. Garnishment's a collection proceeding separate from the underlying case. You have to bring it, and you have to bring it in the right effing place. And this isn't it. That's what's going on.
Please do. I would appreciate that very much if you do that today.
All right. Mr. Saptowski, I take it you wouldn't have an objection to the court entering a garnishment order, is that right?
I have no objection, Your Honor.
Because that just puts the squeeze right on him, sir. I know right where to go next.
Him, just to make sure.
Learman Electronic Tool.
Okay.
Then I know right where to go next. I know what courtroom to go to next. So I appreciate your time, sir. You did a really good thing today.
Well, thank you. I will, given your request and the lack of objection, enter a garnishment order for 25% net disposable income, which is
actually no, Your Honor. I have no objection. You could ask for the whole 100%.
I'm not allowed to under the law.
Well, how much are you allowed to under the law?
25% of your net disposable income.
Oh my God, they might do it differently. I don't know why, but he entered a garnishment order against himself. He's not the garnishment defendant, his employer is. But what he just asked the judge to do is have his employer take money out for somebody else. The level of stupidity here is so profound. I'm not going to waste more time explaining it.
Are you sure? I mean, I know you are, you're the judge, but.
This is one thing I do 1,000 times a month, so yes.
This is the first courtroom I've been in 25 years where I haven't been scared, sir.
All right, well,
I appreciate that. I just want to make sure you understand that I appreciate that.
Thank you.
I was just in that courtroom 2 weeks ago, terrified.
Okay.
You should have had that seat, sir.
Oh, well, I appreciate your kind words. What I'll do, just to be abundantly clear, in my garnishment order to Leader, I will ask my court reporter to get with me to put some language in that the court recognizes that, let me take it, make sure, Mr. Sapkowski, do you have any objection to extra language that the court recognizes that there may well be a superior lien based on, and I'll go into the wording that the defendant has put forth in a separate case. I'm not sure what the plaintiff's position is on that.
No, I have no objection, Your Honor.
Okay, then I'll specifically enter the garnishment order, but indicate the court without objection, plaintiff is saying this is inferior to that prior.
I just have one issue right now, and it's what you said and he said, and that is that you've attempted to serve the garnishee. Truth of the matter is, Your Honor,
they're not
I have
happy with
served
you.
the garnishee right here. I'm going to hand it to him if I can find it. I sent the entire master packet to the garnishee. It went to his business 2 weeks ago Friday, and now it's sitting at the post office. He refuses to go get it. Now, he had a duty to the Secretary of State when he moved from 6th Street to County Road 105 to tell them so that they wouldn't be lost right now. And so we can't allow him to just skate on that default because, Your Honor, under the law, that's a default. He has a statutory duty to update his address.
Well, as Mr. Sapkowski knows, because he's in my court a lot, I will routinely grant garnishment orders. And my joking theory is under the no harm, no foul theory. If I send it to an employer who is the employer, they can act on it and note it. If I send it to an employer who is no longer the employer, they don't need to take any action. So
well, I'm still employed with him.
Okay.
That's what the record reads. His lawyers have said I was not terminated. Title 4D, both Elkhart Stark says I ain't been terminated. And the FROI is sitting there.
Okay. Well, and that's why I'll.
So I appreciate it. You put that garnishment in. That way he knows I'm coming.
All right.
That's just more footsteps for him, foot stomping steps for him to have to listen to.
Sounds good.
I appreciate your time today, sir.
You know, I do have two requests. First off, the court indicated a moment ago that the court would issue an order indicating that this garnishment order is junior to whatever other garnishment. I think that would be fine if the other garnishment is I think there's a child support.
Two of them, Title 4D.
However, if there is some other lien that the defendant's claiming because of a workers' comp case, then I don't think, I don't.
There ain't no workers' comp case no more. I had the Attorney General down here 2 weeks ago, sitting right over there. He admitted under the record
All right, well,
that the WCB never had the FROI, so they never had jurisdiction.
Okay, so as long as the court's order,
it's a statutory definition anyway.
Let me please hear it, Mr. Sapkowski.
Doesn't establish that my client's lien is junior to some fictitious lien.
It's not a fictitious lien, sir. It's right here.
I just don't know what the other lien is, Your Honor. I guess my point
This is the lien right here, sir. It's not fictitious.
Okay.
It's $300,000, and it's legit.
Whatever that is.
It's senior. It's senior to your debt's what it is, sir.
I don't think that's a real thing. So if the court's order were to say that my client's garnishment is junior to any child support lien, certainly. But as for this $300,000 lien, which according to what I know, doesn't result from any judgment or any actual lien, I would object to the court issuing an order establishing that.
Okay. Your response?
Your Honor, you gave him till May 21st to say what he just said, and he didn't say it by then, so why does he get to say it now?
Yeah, and I recognize that, and I really like when deadlines are followed, but I also need to follow the law even when it's late. There's kind of a theory, we issue default judgments all the time when defendants don't get served, and then they come in a month or a year later and say, hey, I have all these reasons. And if they have good reasons, I sometimes vacate my orders and go ahead. And for the same theories, I will sometimes allow someone to make an argument beyond a deadline. But that being said, I think what I'm going to do, gentlemen, is be intentionally vague in my garnishment order and just say the court recognized that recognizes that this garnishment order out of Superior Court 5 is inferior to multiple other liens. And I'll leave it at that, and I think that might.
God bless you, sir. God bless you.
Is that okay? Sure.
God bless you.
Was there something else? I think you said you had 2 items.
Just wanted to establish that the garnishee's address is Funnel Card, is that correct?
Yes, it is.
Okay,
Now, when did you get that?
just a minute ago.
Okay. Your Honor, I appreciate your time.
Okay,
I'm sorry.
thank you, gentlemen.
I really am.
Thank you, Your Honor.
Have a good
I
afternoon.
appreciate, Your Honor, you are the greatest judge 25 years I've ever seen.
Oh, thank you. I really appreciate that.
You're the man.
Thanks.
I appreciate you, sir.
Thanks.
26-49968, estate of Ryan George Richardson.
Suck up.
Ad litem Allison Spencer appearing, Your Honor.
Judge Megan White is the applicant attorney and my client is also present.
Is that Mr. Bartley?
Ronald Richardson,
Oh,
excuse me.
I see him. Okay, so Ms. White, you wanted this.
Yes, Judge, and I believe that Ron is the witness present.
Is that Mr. Bartley, the witness?
Yes, he is. He said he's in the waiting room.
Yeah, he's wearing a baseball hat, which isn't.
Your Honor, if you don't mind.
Hang on one second, Ms. Spencer. He's wearing a baseball hat, which is not court appropriate. So could you just text him maybe?
No, because I'm telling you the truth. I'm very gay now, and
Fix that. All right, Ms. Spencer, what's going on?
I would just prefer not having the witness appear. The complaint that I had was that the witness had gaps in personal knowledge, and I asked for a different witness and didn't get one. So I went out looking for different witnesses. I found some, but then the applicant apparently contacted them and they declined to be involved. I am not getting cooperation from applicant or applicant's attorney on getting phone numbers, locations, emails of the people that I need to speak with, which included, the person who lived with the deceased in the home, who is apparently a partner. They're just not giving me what I'm asking for. This witness that I think they've brought in, I've reviewed thoroughly. He does have gaps in knowledge. I don't think he's going to be a witness. He was the friend of the father of deceased.
Judge, none of this is relevant to today's hearing. He's here because of her hostile behavior.
We're not having a hearing. We're not having a hearing today. This was a status conference, which begs the question, why are we having a witness or anything like that? That's not what you do in a status conference.
Right. Yes, Judge, I'm just having.
Let's talk about what, there's clearly an issue. So let's talk about that.
So I just need to get in touch with.
Hang on. Ms. White wanted the status conference. So I want to know from Ms. White, what's going on?
Thank you, Judge. We've been having some difficulty with our ad litem, and I didn't want to have to file a motion to remove. I was desperate to not have to do that. And quite frankly, she's done work. That's great. The issues that I'm having, though, is Allison kind of touched on some of it, is we have no problem. I have offered another witness. Allison contacted this second witness a second time and was hostile towards him.
Is that Mr. Bartley?
Yes, Judge. And my client's just frustrated, as you can imagine. She was appointed on the 8th. I have several communication attempts that I reached out to Allison, had not heard back at all. I got 2 responses from her office, one of which said back in April that she would contact me the following Wednesday, did not. And I'd be happy to share with you the the correspondence that I received from Allison. They are incredibly inappropriate and unprofessional. And instead of
Unbelievable.
I'm happy to share with the court, Judge.
Your Honor, in 23 years, I've never been accused of anything. I have a great reputation in this county. I can show you all of my communication and also all of my responses to her communication that said, we simply are not finished with our investigation. There are many holes in this. This decedent died in March. They filed in April. And within weeks, this council has asked me to expedite this case. I cannot. I'm not in touch with the relevant fact witnesses that I need to speak to finish this. This witness that's apparently in the lobby was very evasive, not answering my questions that are just standard questions, Your Honor, that I ask on every single case. He wouldn't give me information. And then he's actually the person who called me I was a little bit surprised. I had told Miss White that I needed a different witness, that I just had, gaps in knowledge on this witness. That's all. And then I get this call from this man saying, basically, I'm the only witness. I'm approved. I know the family. And I said, thank you, but I need more information than what you're able to provide.
Judge, just for reference, this witness has known the decedent since, most of his life. And again, I did offer. The first email back on May 27th response that I'd ever received from the ad litem, despite my phone call attempts and email attempts, she would like to know, he's 41. He passed away at 40.
All I can tell you is I'm feeling an estrogen overload in this hearing. It's palpable.
Never married, no children, Judge. She would like to know where the decedent resided over the last 25 years. She wanted to know suspected romantic partners, understandable, known roommates, no problem. Names of businesses for which decedent worked since the year 2000, including years, location, known supervisor or coworker names. And now we have a witness problem. My client, we're afraid of what's next. If I give you another witness and now she's demanding to speak to a third party that my client did not contact after Allison contacted me. My client asked him to be a witness following our initial phone consult. So before he even hired me, I told him what the expectations were. Witnesses were needed. So he reached out to this individual and the individual said, hey, Ronnie, I love you, but I don't want to be involved with any of this, probably because he's heard horrible things about the probate process. And it was that simple. And so that was my response to Allison this last week was, hey, Allison, I can get you another witness. No problem. We have no problem with that. And I immediately sent her a resume for the decedent. I don't even know if that's sufficient for her. At this point, my client's frustrated. He doesn't want to lose his brother's home to foreclosure. He is antsy. He is very antsy because this was filed on April 8th, she was appointed. We need to get moving. Whitney Thompson was on my last case and was done in a week.
I've been working the entire time since the appointment, and the questions I have asked have not been answered by the witnesses provided by the applicant or by the council. And the reason I asked, he's moved around. He wasn't just stationed in this area. And, there are some facts, which I know we don't want to delve into the facts of the case right here, but there are definite facts in this case that raise eyebrows for me that I need to answer as to where he lived, what his activities were, outside of these people's knowledge. And there are some strange circumstances. I also wasn't provided basic things.
And this, ladies and gentlemen, is why I hire a probate attorney to handle probate stuff when I have a wrongful death case. Shout out to Sue. Turns out she's a female. I say, Sue, could you go in there and take care of that witchcraft for me and then tell me when we're done? Thank you very much. She's excellent.
It's like the death certificate by counsel until maybe 2 or so weeks ago. And I feel like if I can just get the contact information for the 2 people that I've identified were actually the closest to this decedent, I would be able to complete my investigation. I've requested that and not been given it.
That was just on Tuesday, Judge. And I just want to make that was literally just on Tuesday, less than 48 hours ago.
Okay. Well,
for the first
Mr.
time.
Richardson here, do y'all have that contact information?
I do. I've provided the contact information, but again, one of those witnesses respectfully asked me that he did not want to be involved. The other witness is the girlfriend, and she had been with him for 4 years. The witnesses that I provided have both known him for over 20 years. I thought that they were better witnesses than the girlfriend, who had only known him for 4, didn't know any of his time when he was traveling for work. And so I just provided what I was asked to provide, which were 2 good witnesses for this case.
Okay. So, Ms. White, let's get those witnesses that she wants to her. If you want to have a hearing to remove her where you get testimony and everything, then you need to file a motion for that.
Yes, Judge.
Okay, requesting that relief.
So you want me to provide the information for the witness that has been asked not to be involved? Do you want me to go back to him and ask him to reconsider?
You don't have to ask him anything. You just need to provide the information. And then Ms. Spencer will pursue that lead, and then we'll go from there.
Thank you, Your Honor.
What happens.
And Judge, I just wanted to point out, I only needed the status conference. I requested it last week because nothing had been done. And then once I said it, miraculously, we're getting
And
along.
honestly, Your Honor, that is not a true statement. I have been working diligently on this case for 2 months. And just because she's not getting an expedited favor that she
I'm not getting any
requested,
response.
And,
No
and
response.
honestly, Your Honor, she never said anything about the home until about 2 or 3 weeks ago.
Long
I was
time.
never made aware that there was a reason to push this forward. It was just, hey, let's just get this hearing as quickly as possible. Your Honor, I treat every case with the same amount of ethical, understanding and due diligence. And this case required more. And I'm sorry that may have not suited the time frame that the applicant was hoping for, but I've also not been provided multiple times a third witness as requested. And then I went out and found my own 2 witnesses that I could speak to, and also was not provided their contact information, even as I think I requested it on Friday or Sunday.
This right here applies to literally everyone on screen.
She just needs an Italian sausage and a corn dog, and that would fix her right up.
When I got those names, and I tried to reach out to them myself and just had, cannot find a good number for them online. They have indicated that they have the information, and they're not sharing it with me all week, even before they knew that we would have to appear before you, Your Honor.
Okay, well, they're going to share the information. Ms. White, with regard to the home, if you need some kind of injunctive relief, of course, that's available to you. Also, if it gets to the point where you maybe need a limited temporary administration to get you through that process, we certainly don't want the home foreclosed on. So we have some tools available to us. Mr. Richardson, go ahead and let Mr. Bartley know we're not going to hear from him today because this wasn't noticed as any kind of motion to remove. It's just a status conference.
Sure.
So hopefully we can get through this and get Ms. Spencer's questions answered. If we need to talk again, come back.
Okay.
Thank you, Your Honor.
Judge, I've never had any issue like this before. Since 2026, Kyle and I have filed 31 cases in your court. 31.
I've never had an issue with you before, and I've never had an issue with Ms. Spencer before. So I'm kind of.
I've never had an issue. She's a stinky bee. And the one she's calling a stinky bee is saying, I am world renowned, the greatest attorney of all time, and everybody knows it. And the other one's a stinky bee. That's what's going on.
At a loss because I'm like, wow, I'm looking at, 2 attorneys who, it's just sometimes you just get that situation that kind of might be, I don't know. Maybe the municipal, I don't know. But
Your Honor, I do look forward to being able to complete the investigation with the information that I've requested. So as soon as I have that, I promise you to have a good answer to you as far as moving forward with the hearing, but I do need the information that I have requested.
Okay, thank you.
Thank you, Judge.
Oh, good Lord. Okay, I'm out of nuggets for the moment. That's what I had. I just kept going because Biggin was down. What do we have? We had a pile of fun with Judge Dad. We had a SovCit who overstood. We had a garnishment issue, which we'll never speak of again. And then we had the estrogen-fueled Thunderdome. I think that's good enough for now. That's a complete stream. Thank you all for coming on. I appreciate it.